I'm delighted to have an opportunity to talk to you about that decision. As you know, in RFRA, the Religious Freedom Restoration Act, Congress was dissatisfied with the protection afforded by the Supreme Court under the First Amendment to religious exercise. The court, in a case called Smith versus Maryland, written by Justice Scalia, of general applicability is fine. That doesn't offend the First Amendment. So laws banning the use of peyote, Native Americans, tough luck, even though it's essential to their religious exercise, for example. All right. This Congress decided that that was insufficient protection for religion. And in a bill sponsored by Senator Hatch, Senator Kennedy, Senator Schumer when he was in the House, wrote a very, very strict law. And it says that any sincerely held religious belief cannot be abridged by the government without a compelling reason, and even then, it has to be narrowly tailored. Strict scrutiny, the highest legal standard known in American law. Okay. I've applied that same law, RFRA and RLUIPA, their companion statutes, to Muslim prisoners in Oklahoma who seek halal meals, to Native Americans who wish to use an existing sweat lodge in Wyoming, and to Little Sisters of the Poor. Hobby Lobby came to court and said, we deserve protections too. We're a small family-held company, small number of people, They exhibit their religious affiliations openly in their business. They pipe in Christian music. They refuse to sell alcohol or things that hold alcohol. They close on Sundays, though it costs them a lot. And they came to court and said, we're entitled to protection too under that law. It's a tough case. We looked at the law, and it says any person with a sincerely held religious belief is basically protected except for strict scrutiny. What does person mean in that statute? Congress didn't define the term. So what does a judge do? A judge goes to the Dictionary Act, as you alluded to, Senator. The Dictionary Act is an act prescribed by Congress that defines terms when they aren't otherwise defined. That's what a good judge does. Doesn't make it up. Goes to the Dictionary Act. And the Dictionary Act, Congress has defined person to include corporation. So you can't rule out the possibility that some companies can exercise religion. And of course, we know churches are often incorporated. And we know nonprofits, like Little Sisters or hospitals, can practice religion. In fact, the government in that case conceded that nonprofit corporations can exercise religion. Conceded that. So that's the case. Then we come to the strict scrutiny side.
I don't want to cut you off.
Oh, I'm sorry.
I'm going to get in big trouble with.
Oh, I don't want to get you in trouble.
Iowa here.
I think I would want you to continue your answering his question.
I'm sorry, Mr. Chairman.
Please,
I apologize.
no, I want you to continue.
Okay, all right. And so then you've got the religion, the first half of the test met, right? So then you go to the second half. Does the government have a compelling interest in the ACA and providing contraceptive care? The Supreme Court of the United States said, we assume yes. We take that. And then the question becomes, is it narrowly tailored to require the Green family to provide it? And the answer there the Supreme Court reached, and precedent binding on us now, and we reached in anticipation, is no, that it wasn't as strictly tailored as it could be because the government had provided different accommodations to churches and to other religious entities. The Greens didn't want to have to write down and sign something saying that they were permitting the use of devices they thought violated their religious beliefs. And the government had accommodated that with respect to other religious entities and couldn't provide an explanation why it couldn't do the same thing here. That's the definition of strict scrutiny. Now, Congress can change the law. It can go back to Smith versus Maryland if it wants to, eliminate RFRA altogether. It could say that only natural persons have rights under RFRA. It could lower the test on strict scrutiny to a lower degree of review if it wished. It has all of those options available, Senator. And if we got it wrong, I'm sorry. but we did our level best, and we were affirmed by the United States Supreme Court. And it's a dialogue, like any statutory dialogue between Congress and the courts.